This is Barry Zalma speaking for Claim School Incorporated's newsletter, Zalma's Insurance Fraud Letter for May 1, 2024, this being Volume 28, Issue Number 9, on May the 1st. Happy Law Day. Zalma's Insurance Fraud Letter is the source for the insurance fraud professional, and it continues its 28th year of publication, dedicated to those involved in reducing the effect of insurance fraud. ZIFL is published 24 times a year by Claim School and is written by me. It is provided free to anyone who visits the site, and this issue contains some of the following articles. First being an article about what is insurance fraud. Next, tax fraud. Insurance fraud is the most practiced crime in the world. It is perpetrated by members of every race, religion, and nationality. It is found in every profession. The possibility of a tax-free profit, when coupled with the commonly held belief that criminal prosecution will probably not occur, is sometimes too difficult for normally honest people to resist. The article on insurance fraud is adapted from my book, Insurance Fraud, Volume 1, Second Edition, which is available as both a Kindle book, a hardcover, and a paperback from the links provided at the blog post. You can also read the complete article and the full issue of ZIFL in Adobe PDF format at the link provided. Then there's a story about why a man bites a dog and the dog bites back, where the Third Circuit compels arbitration of an Insurance Fraud Protection Act qui tam claim. The Insurance Fraud Protection Act, or the IFPA, allows insurers to sue healthcare providers pursuing insurers with assignments of benefits from personal injury protection, or PIP, claims, that is, no-fault insurance, on behalf of the state. GEICO did so against multiple healthcare providers who asked the court to compel GEICO to arbitrate each potential fraud claim. Next is an article about more on McClenny, Mosley, and Associates issues, this being the 27th installment of the saga of McClenny, Mosley, and Associates and its problems with the federal courts in the state of Louisiana, and what appears to be an effort to profit from what some magistrate and district judges indicate may be criminal conduct, to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana. For example, on April 3, 2024, Monson v. MMA et al. Filed a first amended complaint for its class action and damages in the United States Court of Appeal for the Southern District of Texas, Houston Division. You can read the full article and the full issue of ZIFL in Adobe PDF. Then there's a note about the availability of my newest book, the Compact Book of Adjusting Property Claims, 4th edition, which on January 4, 2024 was published in Kindle paperback and hardcover formats. You can read about the book at the link contained in the blog. Then there's an article about a criminal who tried to get out of his sentence and why an insurance fraudster failed to obtain post-conviction relief. Robert Sittler appealed from the order that dismissed his petition, filed pursuant to the Post-Conviction Relief Act, A jury found him guilty of homicide by vehicle, and the trial court sitting without a jury. In Commonwealth of Pennsylvania versus Sittler, the Superior Court of Pennsylvania on April 11, 2024, refused to provide relief for Mr. Sittler. Then there's an article from the Coalition Against Insurance Fraud about Tiberius M. Hayward, an insurance fraud ringleader who specialized in staged automobile accidents, had been found to plead guilty in Sumter, South Carolina. And you can read the full article at the link provided. Then we have health insurance fraud convictions, starting with a doctor convicted for $5.4 million Medicare fraud scheme. Adarsh Gupta, MD, 51, of Sewell, New Jersey, was convicted by a federal jury in New Jersey for causing the submission of over $5.4 million in fraudulent claims to Medicare for orthotic braces ordered through a telemarketing scheme. One of the patients had both legs amputated, so there was really no reason for orthotic braces. Next is an article about why an insurer is immune from malicious prosecution suits, even because its SIU made a good faith report to the state about a suspicious insurance fraud. In Hanover Insurance Group and Michael Arline versus Luke Frazier, an April 3, 2024 decision of the Florida Court of Appeals, Luke Frazier sued the Hanover Insurance Group and Michael Arline, Jr., an employee of Hanover's Special Investigation Unit, for malicious prosecution. The court found them both to be immune from suit because of the language of the Insurance Fraud Prevention Act that required the insurer to report suspected fraud. Then there's an article with a new book, now available, Property Investigation Checklists Uncovering Insurance Fraud, 14th edition, that I wrote and updated into the 14th edition. The book provides detailed guidance and practical information on the 4 primary areas of any investigation of suspicious claims and is available from Thomson Reuters with links provided in the Insurance Claims Library, the link for which is in the blog. Then there's a listing of other insurance other than health insurance fraud convictions, starting with the conviction of a self-proclaimed godfather who got 54 years in prison because of a $150 million Southern California workers' compensation scheme. Payman Haidari, 53, a man who Riverside County Superior Court records say called himself the Godfather, was ordered to serve 54 years in state prison. You can read the full article and a list of additional insurance fraud convictions at the link provided in the blog. Then there's an article about why a criminal's money stayed with the state after his assets were forfeited to the state because of his conviction for insurance fraud. In BD versus Sussex County Prosecutor's Office, the Superior Court of New Jersey Appellate Division on April 19, 2024, dealt with the claims of a victim of a sex offender who attempted to get assets of the offender that was forfeited to the state because of his conviction for insurance fraud. In the declaratory relief action, plaintiff B.D. appealed from the Law Division's order dismissing his complaint, in which he sought to obtain proceeds forfeited to the Sussex County Prosecutor's Office in a related health care and health insurance fraud case. But because all of the defendant's assets were forfeited before a judgment was obtained, he had nothing to attach. And finally, an article about attorney Eric B. Dick, who faces sanctions again from the Galveston County District Court, who recently ruled that Dick filed a groundless lawsuit against Standard Casualty Company in bad faith, resulting in a summary judgment ordering Dick and the Dick law firm to reimburse the insurer over $100,000. This judgment follows a similar sanction of $137,000 in Harris County Civil Court against Dick for frivolous litigation against the same insurer. You can read the complete article in a full issue of ZIFL in the link provided in Adobe PDF format at the link provided in the blog. Thank you for your attention.